Data is the new oil. It is very rightly said, because in today's day and age, data is one of the single most important tool across the whole world. It is important for individuals, of course. It is important for organizations, for companies. It is important for the governments. It is important for security agencies, and it is important for all spheres of our lives and all aspects of our lives.
Central government has officially notified the Digital Personal Data Protection Rules 2025.
Shops will no longer be allowed to demand your number, all thanks to the new DPDP rules. That's Digital Personal Data Protection Rules.
डेटा प्रोटेक्शन बिल देश के हर नागरिक को एक नया विश्वास देने वाला बिल है.
Excessive centralization of all the data. Everything will be controlled. It's a complete insult and hurting the spirit of the federal structure of government.
The bill does not provide for compensation to individual. Personal data has been compromised or who has suffered loss due to theft of personal data.
Given the vast number of objections you have heard, Mr. Chairman, I would urge that the bill be sent to the Standing Committee for proper examination as a new bill, because for the three different versions do not match.
Has crashed into one of the towers of
Now, some of you would know that in 2017, there was a very historic judgment known as K.S. Puttaswamy judgment, where Honorable Supreme Court of India highlighted the right to privacy as a fundamental right of an individual. Now, in this specific instance, data becomes very, very important, because right to privacy, under that, if you see very specifically, data is at the center, data is at the core. But this act has not been operationalized as of now, which is why the central government notified very recently Digital Personal Data Protection Rules of 2025. Basically marking the full operationalization of the act which was passed in the year 2023. Now, together, this act and rules, they very clearly mark a clear and a citizen-centric framework for the responsible use of a digital personal data of individuals, which is why this rules becomes very, very important, and the Data Protection Act also becomes very, very important. Now, first of all, let's talk about the rules. The short form is DPDP rules, that is Digital Personal Data Protection Rules. Now, it operationalizes the DPDP Act, which we already know, but it also creates a practical system for personal data protection in the country. And how is it creating a practical system? Let's see. First of all, these particular rules, they strengthen citizen rights with respect to personal data. Also, they support innovation, and also they ensure responsible data use of every individual by organizations, and they are curbing any unauthorized use of any data. That is very important part. Another important part is that these rules are reducing digital harms to an individual. Also, they are helping in building a very secure, a very trustable, a reliable digital economy of India. Again, an important aspect. Alongside this DPDP framework, it's always putting citizens first, which is why it's a citizen-centric approach, and it's putting citizen at the center of data protection, which is why citizens are being given complete control over their personal data. So we all are using social media apps today, whether it be Facebook, Instagram, X, or whether it be Snapchat, or whether it be any other applications as well. For example, Google Map services, or other services provided by Google as well. What we will be able to find if we dig minutely, we'll be able to find one very specific thing, that almost all these apps are actually taking up your data.
The private information of more than 500 million Facebook users may have been compromised, and an unidentified leaker says they are offering the data for sale for virtually nothing.
A U.S. federal court has fined the tech giant. Google has been told to pay $425 million. The reason? Something most of us fear but cannot always prove. Violation of privacy.
Record-breaking data leak has exposed over 16 billion login credentials from major online platforms including Apple, Google, Facebook, GitHub and Telegram.
See, when something is free, there is always an opportunity cost. All these services which are provided to individuals, they are free. Facebook is free for individuals. Instagram is free for individuals. All these, WhatsApp is free for individuals. But the question is then, how are they earning money? So basically, if the product is free for you, it's actually you who's paying the cost. The cost is your data. That is, they are taking up your data. In actuality, your phone actually knows more than what you would remember of yourself, or what anyone would know more than you.
अब यहाँ पर एड्रेस में आपके घर का पता है, आप एक बिल्डिंग में रहते हैं 14th फ्लोर पे 17th फ्लोर पे, तो उसको पता है क्या 14th फ्लोर पे रहते हैं 17th फ्लोर पे रहते हैं?
क्या इतना स्पेसिफिक?
इतना, ये एड्रेस का मतलब यही है. इस एड्रेस का मतलब लोकेशन नहीं है, एड्रेस.
जो कि हमने कभी दिया ही
जो
नहीं
हमने
है
कभी नहीं दिया.
Why? Because your phone is able to track your data even to the minutest. See what kind of restaurants you visit, what kind of dishes you like to eat, what is your payment system, how do you pay, what is your behavior in at night, what is your behavior in the days, what kind of apps you like to scroll in this specific period of the day. All these things, data is about you, your phone knows, or your digital platform knows, or your laptop knows, or your tablet knows.
And you may remember what happened last year. Google was told to destroy billions of user records. Apparently, it tracked people even though they were browsing privately on the incognito mode. The fact is, most apps are talking to other apps. They're harvesting our information, tracking our moves like an assassin, and mutely collecting our queries, our preferences, passions, anxieties, everything.
Data is very, very essential, and protecting this data is very, very essential, because if this data gets on the hand of someone who's immoral, who's unethical, you can be in trouble, and individuals can be in a vulnerable stage if their data is compromised, which is why this particular rules are very, very integral, very, very important. Now, very briefly, let's try to understand what are the core provisions of these rules. See, first is phased implementation, which is why these rules won't be implemented at one go. There is a time horizon over a period of 18 months. So these rules allow a 18-month compliance window for all the companies, organizations to update their systems and also adopt responsible practices. So it's not an abrupt rule that it is started and implemented today, and today itself we'll be levying penalties. No, a separate window is given to the organizations, to individuals, and for every stakeholder to understand about these rules and to comply with these rules properly. So specific window is being given. And also data fiduciaries, they must issue very simple, purpose-specific consent notes, and all the consent managers must be India-based companies. That is another rule which is present under the DPDP rules. So data breaches must be reported to individuals who are affected with immediate effect without any delay. Alongside that, these data breaches must be reported in plain and simple language which individual is able to understand and comprehend, and where the incident is also explained, where potential impact is also explained, and steps taken by the organization to remedify the situation, that is also explained, alongside clear consent details and contact details for assistance. That is very, very important under this DPDP rules. And of course, the core principle of accountability, the core principle of transparency is at the core of these particular rules, which is why data fiduciaries must display their clear contact information for data-related queries of any individual which might be. And as well as this, significant data fiduciaries must undergo independent audits, which means the data fiduciaries which are very big, they must undergo independent audits, which is important for the organization as well, important for fiduciary as well, important for individuals also. Alongside this, a data protection board would also be set up. So these rules are setting up a fully functional data protection board with the 4 members, allowing the citizens to file and track complaints online through a portal or through an app, which means there is a remedy also available to the individuals in case if their data is breached. And this particular board is known as Data Protection Board. Now, any appeal against the decision made by the board would be done under an appellate tribunal known as TDSAT. So again, appellate tribunal is also given under these particular rules. And not just this, individuals are also given the option to access, correct, update, or request a deletion of their personal data, and they might also nominate someone to act on their behalf as well. Again, an important aspect, and all such requests must be resolved within 90 days. So a time frame is also given for the organizations where they have to accept the request of the individuals. And all these are the core provisions of a digital data protection rules. Now, since we know about the rules, one specific thing which I told you at the start is that these rules are to operationalize the Digital Personal Data Protection Act. Now, this DPDP Act of 2023 is important in itself. Now, this act is important because it sets out a framework for India for protection of individual data, and that to digital data, which is why it explains the duties of organizations handling such level of data of individuals. Also, it follows a very subtle principle. Now, what is subtle principle? Which means a principle or an approach or a framework which is based on simple, accessible, rational, and accountable approach. So simple, accessible, rational, and accountable approach is a part of this DPDP Act. And also they maintain that the rules must be simple, must be clear, and must be easy to follow, so that a layman can also understand these rules and can implement these rules and can enact their rights. Now, one more thing to note here is that this DPDP framework, it aligns with the Right to Information Act of 2005 as well, where it is balancing the privacy rights of an individual and the right of individual to get information from the public domain as well. Now, coming to the core principle of this particular act, this act is relying on 7 basic core principles. First one is consent and transparency. Second one is purpose limitation. Third one is data minimization. Fourth one is accuracy. Fifth one is a storage limitation. Sixth one is a security safeguards. And the last one is accountability. And all these 7 principles are the core principles of this DPDP Act of 2023. Now, under this act, which we already know about as well, there is a formation of a Data Protection Board of India. The role and responsibility of this Data Protection Board is to oversee compliance, investigate breaches, and ensure corrective steps for data protection of individuals. And it is an independent body which will be performing all these functions. And basically, in simple terms, it will help individuals to protect their right and strengthen trust in India's digital framework, digital ecosystem. Now, there is one term which I repeated earlier. The term was a digital fiduciary. Now, digital fiduciary is a very simple term. Digital fiduciary is an entity that decides who and how your personal data will be used or processed, either alone or with others. So it's an entity which is deciding what to do with your data. That is your data fiduciary. Earlier we were repeating this term, so I hope you are able to understand the term as well. Now coming to the penalties part. Now this particular act, a breach of individual data, definitely carries a lot of penalties. Now specific penalties, if you see, this act is imposing strict penalties on data fiduciaries, including fine up to 250 crores for failing to maintain security safeguards. Now for example, certain crimes like not reporting data breaches or violating child-related provisions, they can carry maximum penalty, or penalties can be levied up to 200 crores in them, while other violations might attract fines up to 50 crores or even lesser than that. But yes, there are hefty penalties on organizations in the instance of data breach, or in instance of not reporting data breach or violating child-related provisions or other provisions as well. And which is why this makes this DPDP Act very, very significant, very, very important, because it increases the privacy rights of individuals and still keeps the RTI Act intact. Now, last but not the least, in a holistic way, let us try to understand what are the rights and protections available to individuals in case of this DPDP Act. See, there are several rights which individual is able to enjoy or individual is able to enact under this particular act. See, first is right to give or refuse consent towards their data. Another very, very integral right. Second is right to know how their data is being used. So individuals are having the right to know that how organizations, how data fiduciaries are using their data. Second right, again, very, very important. The third one is right to access personal data. So our personal data, I have the right to access my personal data at any point of time. And then if you remember correctly, I told you individuals have a right to correct their personal data as well. They have the right to update their personal data as well. And alongside this, they have the right to erase their personal data as well, as and when individual wants. So data is now of individual and not of the organization. Very clearly it is mentioned in this act. And we have also the right to nominate another person who will be taking decisions on our behalf and someone who can exercise these data rights on our behalf. So that is another right which is given under this DPDP Act. And also one more right which we get is that we need to have or we need to get a mandatory 90-day response. Another right is there. And also we need to be protected during data breaches. Another important function, and there should be absolute clear contact for queries, another provision which is integral, and a special protection being provided for children and persons with disabilities, again enshrines that this particular DPDP Act is pro-citizen, is very important for individuals' data. Now conclusively, we can very clearly state that this DPDP Act is important and integral for clear citizen-focused system for ensuring a digital economy which is free from externalities, negative externalities, and which is inclusive, which is protected, which is safe, which is secure, and which is individual-centric, citizen-centric, and which is not organization-centric, which is why this particular act can be called as a pro-citizen act, can be called as a pro-citizen rules, because they are helping in creating an atmosphere, an ecosystem where individual rights are given more important than profit motive, than business motive, because today data is nothing but a business, and a very big business ecosystem has been created over individuals' data, whereby individuals are getting nothing, but individuals are being used because their data is being used by these organizations, and that too in most of the times in a wrong way. And the individuals are not aware where their data is going or where their data is being used, which is why this act and these rules are 21st century innovation by India, and which shows that India's law and governance are going on the right track, and definitely we are updating with the time. I hope you gain new perspective from this session. Do let me know what are your comments regarding this. All the best and have a very beautiful day. Thank you.